You are listening to the Novel Writing Podcast, episode 196. I'm your host, Colleen Mitchell. Grab a cup, cozy up, and let's get to writing. Today I'm chatting with Samantha Bradshaw, a small business and intellectual property lawyer who works with creative entrepreneurs to keep their work legally protected. She's deeply connected to the writing community, helping authors, coaches, and creatives safeguard their ideas, brand names, and hard-earned IP. I'm excited to talk to Samantha today, especially in light of the recent decisions in federal court that kind of handed a win to AI, and that was ruling that large language models training on copyrighted work falls under fair use. I, along with the vast majority of authors, feel like that was a terrible decision, and it calls into question how we can protect our work if AI is allowed to train on it. And we do have to have a little bit of a caveat here that whatever we talk about in this episode isn't a guarantee of what things will look like even a week from now. Things are changing so fast. So by the time this episode comes out, this information might be outdated. So listeners beware. With that out of the way, Samantha, welcome to the podcast.
Thank you so much. I'm excited to be here. And I'm excited to talk about this. I mean, like you just said, rapidly changing area of law. And we're going to try to delegalize it. I'm going to try to, make it not as lawyery as possible. But the reality is just the structural setup of the US court system means we're going to have to probably learn a few things. And I'm so sorry.
That's okay. I mean, are there any like preliminary definitions that we should get out of the way before we start?
Oh yeah. So let's go with the absolute starting point that the case that you're talking about that is going through federal courts is still only at the circuit level. It has not made it up to the Supreme Court level yet, which means it only has authority in a couple of states that are within that circuit. So this is not the law of the land across the United States yet. When we start talking about things getting to the US Supreme Court or things that have been actually written out by Congress, that's when it applies to everybody. So I hope that gives everybody a bit of a sigh of relief on this whole like Anthropic lawsuit, because right now it's out of the federal system in California, which is where all your AI people are based.
That's
but that
fair.
doesn't mean it's not going to see appeals or challenges.
Absolutely. Okay. So are there any other definitions we should know?
I think anybody here that's writing already probably has a decent idea of what fair use is, which is essentially the exception to being able to use somebody's intellectual property. But the basic idea of it is that within certain contexts, we allow folks to use your news article or a clipping of your book or a section of your cookbook in order to educate, in order to comment on it, in order to make satire. That's why South Park can exist, by the way, because they're constantly poking fun at the clearly copyrighted or trademarked material that they're working with. So being aware that AI, that Anthropic's defense to this whole thing of being able to use all of these authors' materials, fiction, nonfiction, otherwise, was fair use, right? And that's understanding that definition is constantly changing by the interpretation of judges, and it's going to keep changing.
That's great.
That's great.
Okay, well, with definitions out of the way, can I have our listeners hear a little bit more about your background and how you got into working with creatives on copyright law in particular?
Absolutely. So I've been doing this whole lawyer thing for the better part of, dear God, pushing 20 years now, between, interning to law school and then, working for other law firms and running my own business as well. And when I left Lebanon, which was 5 years of my legal career after law school, I had the blessing of being able to work with so many medium-sized businesses that just had extra funds to throw at fun things, which, small businesses, bootstrap businesses, we don't necessarily have that luxury. But I was able to watch these businesses throw money at scholarships for writers, helping somebody, get their initial poetry book off the ground because they liked the idea. And I thought that was really fascinating. So when I came back to the States for a little bit, before I started spending most of my time in Brazil, I decided that I wanted to keep working with those small businesses because they were the ones that weren't getting the support, right? They were the ones that couldn't access the support that my guys that had extra money to throw at small things had the ability to do without thinking about it. So I love coming into communities like this and being able to give a bit of a nuanced view that doesn't sound quite so legalese, quite so lawyer. So that way you've got something to go actually work from as a creative. One of my favorite clients, actually, and creative, I love that it's such a broad term because it can include someone who's writing, 10 nonfiction books. It can include someone who's doing a volume of poetry, and it can include one of my favorite clients who used to clean pools. That was their first company. And then they came to me and were like, how much trouble would it be if we wanted mermaids to bartend at parties? I'm like, that is creative, y'all. Creative is a broad spectrum, and I love working with every side of it because this is what, like, I get to write liability waivers for the mermaid fin knocking over a drink. This is a lot more fun than your standard, buttoned up, very posh lawyers operating out of New York or Chicago. What they do is a bit boring. This is much more entertaining.
I kind of want to see the look on the faces of all the buttoned up lawyers reading the contract that has the mermaid knocking over the cup.
I do too. I do too.
Would be great. So the big question for this episode is how can writers protect their work before and after publishing, especially now with how prevalent AI has become?
So let's start with the initial point of legally, what is the biggest protection for writers? It's copyright. Intellectual property actually has three different branches of protections. We have patents, which are for new inventions, new processes. If you, literally made the assembly line for Ford, 100 years ago, that's a new thing. That is a patentable thing. We have a different area called trademark, which is about protecting brands, specifically making sure that consumers don't get confused when they think they're buying something from one company and it's actually from another. So we restrict the ability to use certain words, phrases, smells, sounds, so that it only applies for that one company selling that one thing. So the smell of Play-Doh, only Play-Doh can make clay with that smell. Louis Vuitton had a big fight over the red bottoms on their shoes because they became identified with them, right? The dun-dun in Law and Order, sorry, I'm not a musician, but that thing in the Law and Order bit, that is trademarked because everybody knows it's the Law and Order sound, even though it's only two notes, which is crazy, right? This is really pushing the limits. But also understanding that, the name Dove is trademarked for Dove soap and Dove chocolates, right? So we have this brand protection. And when we start talking about writing, a lot of writers throw trademark off as something they don't need because they're like, oh, I'm not a brand. Honey, you are. If you're writing a series of books and you've got the same title going across the series of books and like bylines under it, that same title is a brand. Everybody knows the next book in your series, if it has that same thing, it's coming from your series. That series is a brand. Your customers, your readers know that came from you. So we've got trademark and patent. Both of those essentially require registration to really be protectable unless you want to wind up in a 5-figure legal battle. And I've seen these things go up to 6 figures pretty easy, even for small businesses. Okay. The beautiful thing is that the third kind of branch of intellectual property, copyright, exists the moment something is created and somebody else can engage with it. Somebody else can listen to it, read it, touch it, feel it, somehow have a connection with that thing physically. There's legal terminology for this, but that doesn't really matter. The point is somebody else can engage with the content that you've produced, right? So when you're talking about writing, that normally looks like your manuscript. And of course, nowadays that's overwhelmingly in digital form. Obviously, it remains to be said, if you are using AI to help write your products, depending on the terms and conditions of which AI you're using, they may automatically have access to what it is that you're writing, to the input that you're putting in. So AI is a tool. It is not the creator. If it is the creator, there's actually been cases saying that AI owns it. The person using AI, hey, I know, I see your eyes. I see your eyes getting really big.
For people listening, I'm like, what? AI can own?
AI can own if all you're doing is copying and pasting what AI has dumped out. I know every person listening to this, every person that's like, wait, let me sit down and listen to the lawyer about how to protect my stuff, is not copying and pasting stuff out of AI and pushing it off on their own. I know you're not doing that, but a lot of digital product creators are, right? But there's a difference between being an author and being a digital product creator.
Yeah. I want to go back to what you said.
Yeah.
For a second, I want to go back to what you said about when copyright exists. You said it's the moment that somebody else can engage with it.
Yes.
That implies that it's a finished product, finished something like it's published, not like my manuscript has been completed and I sent it to my editor. Is that incorrect?
That's incorrect, fortunately, because how many eyes look at it before it's published?
Quite a few.
Okay. What if one of those people took it? If you didn't have rights in it, the second somebody else could read it, then they could just take it and run away with it. So fortunately, that's wrong, right? That's a great thing to be wrong about.
Okay. So
Now,
sorry,
yeah,
another little tangent question.
please.
Something that has been talked about in the writing community, including my own, is if you like one of the best ways to protect that copyright is like your first draft, print it out and then hand edit it and then send it certified mail to yourself and then don't open it once it arrives. How true is that for protections if it's copyrighted the instant it's able to be engaged with by somebody else?
So we have a term for this in the in the lawyer's world, and it's called a poor man's copyright or a poor man's trademark. A lot of
Okay.
people use them interchangeably, but we've just understood that they're not the same protections, right?
Yeah.
This is not real. This does nothing.
Okay.
Not when it comes to showing the day that something was created for you. Unless you're on a typewriter, right? Unless you're like Post Maloning the lyrics for this song, there are going to be different pieces of evidence of metadata in the document, right? Whether you're writing on Google Docs or Microsoft Word or whatever the case may be, there's going to be metadata in that document of every time you hit save, of every time you completed a paragraph. We have that. You don't need to mail it. It's okay. We've got that information there. The only reason that kind of information starts coming to be important is if somebody else, literally the person that you hand your manuscript to the day after, publishes it. And then you're like, wait, that's mine. And you now have to prove who put it out first. But that's why it's so fortunate that the copyright exists the second it's created and readable by another person.
Okay.
Now,
my tangent questions tangent questions are
yeah,
done. Good, continue.
it existing and you being able to enforce the protection of that are different things entirely, right? So just because you have the copyright does not mean the world knows you have the copyright and does not mean the US government's going to support you in protecting that copyright the moment it's created. The best way to do this is to submit the thing to the Copyright Office, the US government Copyright Office. If you're in another country, your country has a version of this too. Go figure out what it is.
That is literally on the list for me to do today for my third book.
Oh, yeah. Yeah. Oh, well, this is perfect timing then.
I know.
So why, besides being a lawyer, right? Why am I so heavy on go register your stuff? The fees to do it with the US Copyright Office for a single work are not that expensive. Like really, they're not. It's very feasible for most bootstrapped people to be able to come up with the fees to register a single book or even a series of blog posts. Because we've seen series of blog posts can turn into books, can turn into movies. So we want to make sure we're protecting it even at the beginning. If there's any idea that you have of this could be something more than what you've created, then that registration becomes even more important. Second big reason I stress registration is back in 2020, the US Congress put together a law that essentially said they were creating a small claims court for copyright issues. The only cases that were allowed to be heard within that small claims court were materials that had already been copyrighted, that had already been registered with the US Copyright Office. Now, if you have ever had to enforce your copyright, you'll find out very quickly that it only exists in federal court, that certain lawyers are, not every lawyer is allowed to operate in federal court. You have to have permission to operate in federal court as an attorney. Any lawyer that has permission to operate in federal court, their retainer starts at $7,500. I don't know when that starts at less. Starts. It's rough, right? Great. And if we have stuff registered, and if we can go to that small claims court, we're not necessarily this federal court that we need a lawyer for anymore. We can represent ourselves. They have made the process much simpler than a normal federal court. It's to where even if you do want to hire an attorney, it's such a restricted process. You're not going to have an attorney that can like blow up your bill the way they can in this other thing. And it's only so somebody has to opt out. If you're trying to sue somebody in this court, you can't force them into it the way you can a federal court, like the normal federal court. They have to say, yes, I'm okay with like submitting to this court. But it does mean that you can tell them, if you don't submit to this court, I can threaten to sue you in the other one. And here's all the reasons why that sucks for everybody. So you want to deal with this one, which is much easier, much simpler. So all of us can get on and move on with our lives. Oh, and by the way, there's something in the law called statutory damages, which basically just means like we have a list of predetermined fees and fines. If you get into this court with a registered piece of copyrighted material, the US Copyright Office says for each piece of copyrighted material, you have a minimum amount of this fine that you can collect from the other person, even if they didn't make money off of it. In the federal court, you have to prove they profited from what they stole, or that you lost something from what they stole. When you're talking about creating the evidence for that, or finding and creating a story around what's happened for that, for most small businesses, for most small authors, that's incredibly difficult. And even if it's not difficult, even if you can prove it, if you were only going to make $5,000 off of it, the $7,500 retainer that you had to pay to that federal lawyer just went out the window.
Right.
It doesn't make sense. You're spending money to defend your own work. So they've created this alternative area that's supposed to be more accessible, faster, cheaper, but you can only access it if you register the copyright with the Copyright Office.
Okay. With that in mind, that it's like your best opportunity or your best chance of protection is a copyright or a trademark. What are the most common pitfalls that authors are falling into with those two things, and how do we avoid them?
Ooh, well, for trademark, it's pretty easy. Authors think they can just trademark anything, and it's not. For books specifically, the things that you want to trademark will be the things that you're selling under. So, like I said, if you're creating a series of something, the series name is trademarkable because that's the brand selling all these different books. In the case of, we've seen Sarah J. Maas is actually a perfect example of this, right? Her books blew up the ACOTAR series, and it's a series, right? Not only did she not register the trademark for the series name, she did not claim or even put an application in, which for her, it would have been worth it. Even if she didn't get the trademark, it would have been worth it just to let people know. Is it Valaris, the city that most of the things happen in?
I've only read the first one and I DNF'd the second, so
okay.
I
Well,
have no idea.
If you haven't gotten to it, doesn't it? There's the pretty city with all the stars and stuff. It happens later in the series.
Oh, then I have no idea which one you're talking about. In any case.
No worries. For anybody who's read ACOTAR, you could probably tell both of us far more about this than I'm telling you. If you're a huge fan of the series, what you'll know is that immediately after that, took off on Book Talk, people all over the world started hosting parties and calling them Valaris parties, or Valaris, or however you say it. I don't know. Because they were and understandable, right? People wanted to dress up like this. They wanted to live the fairy tale. There was a market for this. So entrepreneurs stepped in and said, I will create the space for you to enjoy this. But it was not condoned. It was not approved by Sarah Maas. She had no idea what was going on, and she didn't have the protections set up in place beforehand. My guess is she didn't talk to an IP attorney about what could be amazing in her book, what could blow up, because she could have easily turned this into a side business of dresses by Valaris, parties by Valaris. I don't know. The mats, right? The keyboard mats by Valaris. People started making all sorts of material. Think about the way that Disney shuts down anybody on Etsy that uses
I was
just
thinking of Disney.
Everyone's always thinking of Disney.
Disney will come after you.
Be careful now.
I know. But as you were talking, it kind of reminded me of the Harry Potter release parties. What if they called them Hogwarts parties, or come to the Hogwarts library?
Because there becomes this clear association that you think it's coming from the author. So we've screwed up on two things here, right? We've allowed other businesses, other owners to create something that we no longer control the quality of. And that's a big thing with trademarks, is that you understand, because you think you're buying it from this brand, you think you assume the quality of the thing it is that you're buying, right? Whether it be a mug bedazzled in, Snow White's whistling to a bird shape or something. I don't know. We make the assumption that if it's coming from a brand, it's got a specific quality. And if we allow somebody else to use that brand, we allow somebody else to dilute our quality. We also allow somebody else to make money off of us without our permission. Now, we don't have to be Disney and squash every small creator that's out there. I think the approach is wrong and dangerous. And frankly, in the new era of AI, it's not going to work. What can work is when you have trademarks, even as an author, if you protect, Hogwarts, Valaris, whatever, if you've created a world like that, especially in the nonfiction space, being able to license out the ability for somebody to host that party for you for a fee and require that they have specific things. You're making money. You can spread your brand around the world and control what it looks like. Why would you not give yourself the ability to do that? So that's the trademark side. Anything else popping up, like while we're listening to the whole, Disney, Harry Potter, J.K. Rowling, don't come for me.
No, I think we can talk about copyright now.
Great. So then on the copyright side, yeah, the biggest issue I see is people simply just not getting the registration. Like it is so cheap. It is so cheap. You can put 50 blog posts up with the US Copyright Office for $65. Why? Even if you change the blog posts again next year and that becomes your book compilation, why would you not spend $65 in government fees?
Because people don't know it exists. I didn't know
okay.
I didn't know you could copyright blog posts. I thought it was just for books and
No,
music
we
and
can
things
copyright
like that.
blog posts. We can copyright tweets. We can copyright. I refuse to call them whatever that is they're calling them now. It is a tweet. It is Twitter. I stand by that. Sorry. We can copyright cookbooks. In some cases, you can even copyright code. That's a different discussion, though. That's a deeper discussion. Anything that you have created and somebody else can read is copyrightable. Now, when you start talking about, I don't know if any of your listeners, for example, are cookbook authors. Chefs and recipe designers are, of course, very attached to their recipes, right? I do have to tell you guys this. Recipes themselves are not copyrightable because it's just a list of ingredients. Now, your process of creating that list of ingredients, and please don't come for me. I know everybody who cooks and is like attached to this. In your head, you're like, it's not just a list of ingredients. I know it's not. But legally, for the idea of something that was created by a human that deserves protection exactly as it is, yeah, they don't allow it to happen. Because if we prevented somebody else from using that same list of ingredients, we're preventing somebody else from making your food. What is copyrightable is the blurb about where you got this recipe from, the details on how to do it, the secret steps that make it taste amazing. The butter has to be cold. It can't be room temperature. Let the eggs sit out for a day overnight beforehand. Pat the meat dry, right, until it, feels like your cat's tongue. That stuff is copyrightable.
So is this the very side tangent, but is this why most recipe blog people have their life story above the recipe and you have to click jump to recipe at the top to get through all of that?
But whoever invented the jump to recipe button, please come find me. I love you.
I know. Genius.
I don't know if that's why the recipe folks do that. I suspect it's a bit of like, they want their personality in there. They want to tell their story. And for some things, right, these recipes really are very personal. I also suspect it helps with SEO on a website. I don't know if the recipe folks have had this. Yeah, definitely. I don't know if the recipe folks have heard this, though. I have no idea. I don't know. Let's talk to some recipe people.
Huh,
I've got one, actually. I should message her and be like, why do you do this?
I don't know recipe people.
But I will tell you, so the recipe person that I know that I've worked with, I've helped her with her IP, actually. She was really, really disappointed to learn because she hadn't made any of these registrations. And she signed contracts with another company that she thought on the contracts were just agreeing to promote her stuff. And when, after a couple of years, she was really frustrated because they weren't promoting her recipes as much as they were. They weren't promoting her socials as much as they were, which meant her income significantly dropped. And there was no minimum amount of promotion they had to do in the contract. And she knew that. She's like, okay, well, if they're not going to promote my stuff, then I'm going to go take it elsewhere. Fortunately, her and I had a chat before she did that because the contracts that she signed under the promotion said that everything she created for them was a work for hire, which is legalese for they own it because they paid for it, not her.
That sucks.
That sucks. What was still hers, or nobody's, were her recipes. But actually had a bit of a silver lining. All the blips and everything she had to write, she had to redo, but they were drafted for an internet for a promotion cycle that was 10 years ago. And frankly, wouldn't work anymore anyway. So while she did lose a lot, and she really didn't lose much at all either, right? Because we were thinking about going after them for, not promoting as the contract said they should. Unfortunately, those protections just weren't there. So when you start working with, editors, promoters, agents, it's really important to look at this and be like, okay, who keeps ownership of this stuff? What are your minimum obligations on my side, right? What is it that you have to do for me? Are my expectations of what you've told me you're doing actually what's in the contracts? Because a lot of the times that's not the case. They push a pretty contract in front of you with a lot of dollar figures and you get really excited. Of course, somebody wants to buy your stuff. You've put months, years into this book, the series, whatever it is that you're creating. Taking a moment to breathe and make sure that what it is that you're actually concerned about is protected and still yours within that, it can make a huge difference.
Okay, I think that leads perfectly into the next question I want to talk about, which is using AI for your book, whether it's to help with idea creation on the ChatGPT side or cover design, like with the Canva side, because Canva AI is a whole deal and they have their whole list of policies and stuff. So how do authors use these tools legally and not get in trouble, especially with like the cover design thing?
Okay, so coming up with ideas, and I think anybody in the AI space will tell you this, regardless of whether they're in, project management or content creation, any of that. And you see this in Hollywood even. AI is being used right now to come up with ideas, outlines, timelines. There was even a piece in the New York Times about an author who used Notebook LLM, and he knew he wanted to write about, oh, what was it? I think it was the fur trade in like mid America in the 1700s when the French were running around and the indigenous were joining them. The British were angry about beaver pelts and whatever. He knew he wanted to write about this era, and he bought or licensed all of the material that he dumped into his Notebook LLM, Google's thing where it only reads from the material that you put in it rather than just generating from statistical words thrown together. And he spent weeks having conversations with it, trying to find a new angle, a new side of the story to share, but around the same material. And essentially, with a lot of back and forth, he found out that there was a local indigenous tribe that was crucial to this entire era of showing the British and the French, how to trap, where the beavers were, ended up joining specific sides, even split off. Individuals within that indigenous community were, big proponents of, moving this part of history along. And what did Notebook LLM do? It spit out an entire timeline of where these people were, which is crucial, right? If you're creating a world, especially in the fiction space, knowing that timeline, because your readers are going to come for you if something's wrong, right? So he used Google LM to create that timeline, and then he used it to create almost like descriptions of what each chapter had to be for him once he figured out where he wanted things to be. Google LLM, Notebook LLM, if we think about it, really did a massive chunk of heavy lifting for this book. I don't know if he used it to edit or clarity or anything like that. I mean, there's things like Grammarly now that will completely rewrite a paragraph for you just because it sounds better, right? That being said, what's crucial to understand is even hearing all of this work that an AI did, at the end of the day, he materially changed, right? He did so much work on top of what the AI gave him that what he created was still his. If he had copied and pasted what the AI gave him, no, that's not okay. And also, that's not creative, right? The idea itself, ideas are a dime a dozen. Everybody has ideas. It's actually creating the finished product, the finished business, the finished manuscript that somebody can engage with. That's something that the US intellectual property community deems to be protectable. And then, let's see, what was the second question? Oh, right, the covers. Oh, okay, covers are, trying to think of a good way to, if you go on to Canva and use it to make the logo for your business, because as an author, you are a business, right? What you create is books or magazines or poems, but you are a business on yourself. And if you use any of these AIs to create something and it spits it out just as it is, again, we're going to that fact of the AI created it and you did nothing really. We are running into concerns now. There was a case about Midjourney, as a matter of fact, and it spit out an image that was an entirely new image. It wasn't even a compilation of things like what you can do in Canva, right? Canva, you put all these different elements together. Some of them are pro, you have to pay for them. Some of them are free. Normally, if you've combined them all together into something new, Canva's going to let it go. they're updating their terms and conditions all the time right now too. All the time. They've updated them like 6 times this year. Okay. So the safest answer to this is go read the terms and conditions. If you don't want to read the terms and conditions, put them into Google LLM and say, hey, can I do this? Or ask a lawyer. Okay.
Or
AI
ask a
is
lawyer.
great for this.
Yeah. Yeah.
All right. uh, but so back to the Midjourney one, right? This guy went in and he asked Midjourney to, I'm making up what it was, but I don't know, do a picture of a monkey eating a banana in the style of Cobra, the Brazilian street artist. And it spit out something. He did not stop there. He kept going, and he had the transcript, of course, with Midjourney of how he kept tweaking and altering and all of this. In the end, this was one of the earlier AI cases, right? Midjourney was still completely revolutionary in generating images. It's still revolutionary, but revolutionary in AI, changes every 6 months, every 3 months, maybe at this point. But it was determined back then that because he kept engaging with the AI so much, he genuinely created something new that was worthy of copyright protection. That to say, I mean, the space is changing so quickly and it's so fact specific. If you create something in Midjourney, do you own it? Maybe. Depends on what you did. Depends on their terms and conditions at the time you created it, how much work you put into that. And if you used other people's general styles or you used their exact material, right? Part of that Anthropic lawsuit that we were talking about in the beginning that was so important is that the federal court in California said the books that were legally purchased can be fed into the LLM. It's the ones that they had, because you're getting paid as an author. And then they're not copying what you've done. They are changing it into something wildly different, right? An LLM is not the same as the book you put out. That was essentially the judge's theory. And what a lot of folks are missing is the fact that the judge also said, you mass downloading all these books like your Napster and then feeding them into it and not buying them? No, that's not okay, because that is not the license that came with downloading that book. Because when you buy a book on Amazon, you don't own it.
Right.
You're renting a license to read it for an amount of time, which means chances are it's not feedable into an LLM. And this is actually something that I'm very curious to start watching as a lawyer, of how these licenses start changing for authors when they put their books on these platforms that either send them out digitally for people or are the drop ships that print them and send them off. That way you're not having to physically carry inventory of your own book. And I don't know how that's going to change. I would hope representatives and agents of authors in this space, and they are, right, are fighting and watching this and making sure that they're changing the licenses, because that's just a contract between the author and whoever they give it to of how they're allowed to use it, how they're allowed to sell it. But a lot of it's just going to be determined by that until US Congress, until legislatures all over the world can catch up with how quickly this technology is moving. I mean, imagine you and I are having a conversation today, and I'm already telling you next week, some of this stuff might not be true anymore.
Yeah.
How on earth is a Congress or a parliament supposed to keep up with that speed if you and I can't do it on a single conversation?
And Congress and Parliament are like, they're slow as molasses. So
slower even. Slow as molasses in the wintertime.
Slow as that drop of tar or whatever it was, that like it's one drop every, I don't know, 20 years. That's how slow they are.
Yeah. So I mean, this space is changing very fast, and it will continue to for a long time. I don't foresee the speed of this changing anytime soon. That being said, doing those simple registrations with the Copyright Office, I mean, even if you go for like the special handling, like you have litigation coming up and you're like, I need this tomorrow, it's less than $1,000. Most of the fees there are like less than $400 for anything. That amount of money is so minor compared to what you have the option to lose that it seems like a no-brainer. Right? You get car insurance if you drive. You have a home insurance if you own your car. Or sorry, if you own your home. You probably have renter's insurance if you rent. And the cost of those things, it seems, hopefully your insurance provider is not a jerk, but generally should feel quite minuscule compared to what you have the option to lose if something were to go wrong. This is the same thing.
So we need to start thinking about it kind of like a form of business insurance, because that's kind of what it is. Because we're business owners, our books are our products, we're protecting our products.
Exactly.
Cool.
Couldn't have said it better myself.
All right. Is there anything else that authors should know about AI, about protecting our work, or is there anything that we didn't cover that you want to touch on?
I mean, yes, this could go on forever. But I think the basics of this is, if you've created something that you are worried about being stolen, or you would cry in the bathtub with a tub of ice cream and a glass of wine if somebody started making money off of it that wasn't you tomorrow, it's worth the money to A, register the stuff. B, if you don't want to register the stuff or you're so confused or unsure about how to do it, spend an hour talking to a lawyer. Go to a lawyer that you trust. Go to a lawyer that you like and say, hey, do you know this area of law? Do not go to the DUI lawyer. He cannot help you. You must find somebody who understands this area of law and say, can I have an hour of your time? How much is an hour of your time? And then what I want you to do is I want you to word vomit all of your fears, all of your concerns into an LLM, into an AI. And I want you to ask it to then give you 10 questions that you need to go ask that lawyer, because you're going to walk away from that knowing what your biggest fears are, your next steps to kind of reduce it beyond, what we've just talked about today. And you'll be able to budget and plan if bigger protections are needed, right? And when it comes to intellectual property of any kind, the more visible you are, the more money you're making, the more you have to lose, the more you need to be investing into the protections behind all of this. The higher your risk, the more you should be putting in to protect it. If you're very low risk and you're just writing blog posts for fun and you don't care if someone's going to steal them, don't stress this too much, right? But I will say Julia, right, became an amazing movie, and it was just blog posts. So don't discount yourself either, right? As business owners, as creators, we have a lot of pride and a lot of fear of rejection about our work because it's inherently personal. Don't let that fear of rejection prevent you from creating something that could help, entertain, inspire so many more people than your bubble tells you it could right now.
And I
And I
think
think I'll leave on that.
yeah, and I think I'm gonna end with this, that even if your entire book got fed into an LLM, and even if somebody prompted that AI to write the next book in the series, that book that AI comes out with is never going to be what would have come out of your head.
Correct. Every time.
Yep. All right. What is the best way for listeners to connect with you if they want to talk or ask questions or find out more about what you do?
Yeah, I mean, I would love to hear from any of y'all. I mean, just about how, if this was helpful or if you've got any further questions. We're pretty active on Instagram and TikTok. We're pushing TikTok a lot more now because I spend a lot of time on there personally. I'm like, well, if I do, I should probably like hang out there more as, a lawyer, as a business owner. And you can find me over there at Inline Legal because we help you get your legal in line.
Ah.
I am licensed in Virginia, but when it comes to intellectual property, we can help nationwide. If you're not in Virginia and you've got something outside of this, I actively keep a running list of lawyers that I trust in other states doing other things. I don't want you to go without.
Yeah.
Just because I'm not the one that can help you. I'm always going to try to give you the next steps, even if that's not me. And we're up on YouTube now too. So you can come find us on YouTube. We're putting out fun YouTube videos. That'll be good examples of information like this that will hopefully help you see yourself and how legal protections can, make your life a little bit easier, both as an author and a business owner.
All right. That's awesome. All awesome. So thank you for coming on the podcast. It was really good talking this through with you and learning more about AI and legal.
We'll do it again in 6 months when it's all changed again. Yeah.
I know, right? All right. Well, that is it for today's episode. Thank you for joining us. And remember, the first draft is supposed to be garbage. The Novel Writing Podcast is a production of Colleen Mitchell Writes. For more writing resources, including Curios, Tally Inc. author services, and the 60-day novel writing challenge, check out the links in the description.